This Honorable Court of Criminal Appeals of Tennessee is now in session.
Welcome, everyone, to this call of the February docket here in Nashville, Tennessee. This is February the 10th, the fourth case we've had on the docket this morning. I want to thank Supreme Court Clerk Jim Hibner and his staff, as well as the staff of the AOC for helping us broadcast these oral arguments by Zoom and therefore getting them uploaded onto YouTube. We're giving greater access and hopefully doing our part in trying to somewhat curb the spread of COVID. We thank the lawyers for the extra work that they had to do to be prepared to be here today. I would like for the clerk to go ahead and call the case, and I'll give a little more explanation after that.
State of Tennessee versus Robert E. Huse.
Thank you. The panel for your case today is to my right, Judge Bobby Holloway from Columbia, Tennessee, and to my left, Judge Robert Wiedemeyer from Nashville, Tennessee. I'm John Everett Williams from Carroll County, Tennessee, and delighted to be here with you today. As if we were in person, each side is given 20 minutes per side to present their case. The appellate can reserve time for rebuttal and should do so upon introducing himself to the court. And his time will start now.
Good afternoon, Your Honors. Todd Ridley on behalf of the appellant Robert Huse in this case. If I could have 3 minutes for rebuttal.
Yes, sir. I'll help you keep up with that.
Okay, thank you. Your Honors, the issue today is whether under Rule 404B, the state can rely on a years-old and unsubstantiated claim of abuse of a different child to establish guilt 4 years later establish that Mr. Huse committed a different act of abuse 4 years later of a different child. 404B does not allow that sort of evidence to come in. And because of that, we'd ask this court to reverse the conviction that was ultimately had. So I guess I'd start with the general ideas of 404B and what the trial court did in this case. We'll start by admitting that the trial court followed the correct procedure under Rule 404B. After the motion was filed, the trial court held a hearing and, in general, at least followed the factors that it was expected to apply. So we do understand that the standard we're looking at is an abuse of discretion standard. Nevertheless, the trial court still erred because its conclusion simply cannot be supported by the proof that was presented. First, I'd start with the simple and kind of preliminary question of, did the state establish that the prior act occurred? It did not. So what the state relied on was an act or an alleged act from 2008 involving a child that Mr. Huse had with a different mother. At most, after hearing this evidence, the only thing that the trial court was able to conclude was that Mr. Huse may have been responsible for some of the injuries that that prior child sustained. That's not enough to say that this should come in this case to establish what the state ultimately wanted to or use it to establish. In addition to that, this was not a case like this one where Mr. Huse was the only person accused. In fact, the mother of the child was indicted and pled guilty to abuse in this case, or in that prior case. So that's kind of the preliminary point, that there was simply not clear and convincing evidence that Mr. Huse was in any way involved in this prior child's injuries, let alone enough to support its introduction under Rule 404B. Secondly, the state at the trial level at least relied on a few different theories of admissibility, and the trial court more or less accepted the manner in which the state intended to present it. And its first and I would say central theory of admissibility was that this prior act was admissible under Rule 404B as a signature crime or to show modus operandi, or in other words, to show identity because of the similarities between the acts in 2008 and the alleged acts in 2012. The state, I would say, rightfully conceded in its principal brief that there simply wasn't enough proof to establish that. And I think this court should accept that concession by the state, that if this was going to be admitting it as a signature crime was clearly improper. The reason for that is more or less obvious. given the Supreme Court's, or the state Supreme Court's specificity about signature crimes and how it more or less has to be a unique one-to-one between the prior act and the allegations in the present case to justify admission under that ground. That simply wasn't present here. The similarities were scant and certainly not enough to rise to the level of a signature crime. So I guess I, again, would start by saying this court should simply accept the state's concession on that first point. But what the state does instead is it relies on kind of a secondary theory of admissibility, or the state's secondary theory of admissibility at trial, and says this should have been admissible to show intent. That is not the case. So first off, and this is a critical point, under Rule 404B, the Supreme Court has made clear that something can be admissible only if the issue is material. Intent was not a material issue in this case. It would have been one thing if the defense in this case had been, this was an accident. If Mr. Huse had claimed, I agree that I might have caused some of these injuries, but I certainly didn't do so intentionally. If that had been the theory, if that had been the theory that Mr. Huse had offered, then the state would certainly be allowed to present a prior act to show intent or lack of mistake on Mr. Huse's part. That's not what happened. In this case, instead, Mr. Huse offered to stipulate at trial, it is undisputed that this child's injuries were caused by an intentional act by someone. The only question was who did it and when did it happen? So intent, if that's the theory of admissibility, again, has to be a material issue, and it wasn't. Mr. Huse's offer to stipulate demonstrates that as clearly as anything else possibly could. So the second thing that is relevant to intent is something that the state kind of sort of presented in its brief of, I think it would be safe to say that they were relying on the settled purpose to harm theory. If that were in that theory more or less requires this, if there had been proof that Mr. Huse had previously struck this child, the child at issue in this case, then I think that would be admissible under that theory of admissibility. Mr. Huse had evidenced the settled purpose to harm this specific child by abusing him in the past, and that can be shown that he's used him in this case. But that's not what happened. What the state's instead doing is saying, well, because he at one point in the past may have caused some injury to one child, then he must have intended to cause harm to this child. That's not how the intent theory of admissibility works under Rule 404B. Instead, what the state's really doing is just saying, well, in 2008, he caused an injury to a child. Therefore, he has the general disposition of someone who might cause injury to another child. That is another way of saying propensity. And propensity evidence is precisely what Rule 404B is designed to exclude. So the state's reliance on this intent theory, given that it's a different child and that intent is not really an issue, a material issue in this trial, simply cannot stand. And if Rule 404B is, as the Supreme Court has indicated, meant to be a rule of exclusion, and the courts are meant to take a restrictive approach to it, then this type of evidence is precisely what it's intended to exclude. And if it doesn't exclude this, then I think the state's theory of intent as a means of admissibility would more or less swallow the rule and allow for admission of all kinds of prior acts and more or less treat Rule 404B as more of a suggestion than the restrictive approach that the Supreme Court has indicated that all courts should apply.
Mr. Ridley, I'm trying to follow your argument on general intent versus the defendant's intent to abuse the child. And you're saying that 404B goes to some kind of general intent and not to the specific intent of the defendant?
No, if it's going to the specific intent of the defendant, I would think it would be acceptable. But in this case, the reason it's not doing that is Mr. Huse has conceded that this child was hurt via intentional acts, that someone intentionally caused these injuries. So if the state is saying, well, there's this prior act, and therefore Mr. Huse must have acted intentionally. Well, that's not really an issue in this case because no one's disputing that this child was caused by an intentional act.
No, they're disputing that the defendant intended to cause the abuse. I just don't follow your logic on by the defendant saying somebody intended to abuse the child, that you lose if it's admissible. I'm not saying it isn't 404B, but if it is, why is it not admissible to show it was him that intended to do it?
Well, I think if it were being offered to show that it was him rather than someone else, then that would mean that you're relying on the identity component of 404B as a theory of admissibility. If that's your theory, there was this prior act by a defendant, therefore he did it in this case, well, then I think what you're showing is the prior act is relevant to prove that defendant did it, not someone else. But that's not what they're saying now. Now they're saying we're going to show that he acted intentionally in this case because he acted intentionally in the past. And that's where it becomes just synonymous with propensity evidence, at least at that point. And again, if the proof had been something along the lines of Mr. Huse had caused this specific child an injury in the past, and he caused this specific child injury in this case, then I think that is admissible as a means of intent. And that's under a specific settled purpose to harm doctrine. But that's not what happened here. So I suppose there is kind of a distinction between general and specific intent. But what the state's trying to do is just say he has a predisposition to cause harm to children because of this prior act. Therefore, he must have in this case. And if that's what general intent is broad enough to encompass, then it's broad enough to encompass anything. It's basically just saying any prior act by one person is admissible to show they did it, or it can be used to show that somebody did something in the future. And that's, I think, by definition, propensity evidence. So I guess that's where I kind of have some trouble with the state's theory of admissibility under intent if it's not about Mr. Hughes' specific intent. Okay, so that's kind of the big picture about where I think the Rule 404B errors are. And obviously, any evidentiary error, that's not the end of the equation. There still has to be prejudice as a result of that error. And in this case, the prejudice is abundant. The state's claimed in its brief that there was overwhelming of evidence of guilt. There simply was no such thing. This was a very close case relying on circumstantial evidence. And the biggest problem with this case is, again, Mr. Hughes agreed this child died as a result of intentional acts by someone. It just wasn't me. That was his theory. And so the critical question was, when were these injuries inflicted? And the problem with the state's case is that its own expert did not place the time of injury as being when Mr. Hughes was alone with the child. The state's own expert, its forensic pathologist, said these injuries were inflicted hours earlier when Mr. Hughes did not have custody of this child. So the state's theory is the child is left alone with Mr. Hughes after the child's mother goes to work, and that the injuries must have happened then. Well, its forensic pathologist says those injuries could not have happened in that window. They would have had to have happened a few hours earlier. And so the state's own expert, or the state's own evidence through its expert, simply does not show what its theory of the case was. And because of that, what we wound up with is a purely circumstantial case where the state's relying on yet another expert that contradicted its forensic pathologist to establish when these injuries were inflicted. And if that's where the case is, where you have purely circumstantial evidence coupled with contradictory expert testimony, but within the state's own proof, this isn't through a battle of the experts, it's just the state had two experts and they just disagreed with each other on when these injuries happened. That is not an overwhelming case. And again, the next thing about that is the state relied on this. The state didn't just introduce this evidence and then leave it alone. It brought it up again in its closing, and it went to substantial efforts to get it admitted in the first place. There was this long disputed and contentious Rule 404B hearing, and then again at trial, the state went through great lengths to make sure that there were repeated references to this prior injury of this other child. So the state relied on this. And when it got to its closing, the state relied on this. And it said, 2 injuries, 2 children. We're essentially what they're saying is, we're saying because he did this in the past, he must have done this now. And you should convict him based off that prior act. And that is what propensity evidence is. And that is what Rule 404B is meant to exclude. And because they did it, and because the trial court allowed that to come in, this conviction cannot stand. And it must be reversed and remanded for a new trial. And at the new trial, the state can try again. And the state can try it without this extra evidence. If there's a conviction that follows, fair enough. But this evidence was not the way to get that conviction. And because it was erroneously admitted, this case should be reversed. If there are no further questions, I'll save the remainder of my time for rebuttal.
Thank you. We'll hear from the state.
Your Honors, and may it please the court, Cody Brandon for the state of Tennessee. We respectfully request that this court affirm the judgments of the trial court. Defendant's prior abuse of his son and his cover-up of that abuse was admissible to prove his intent to harm GS and the absence of mistake or accident in harming GS. The state was required to prove at trial that defendant inflicted injury upon GS with the requisite mens rea and did not do so accidentally. Defendants offered stipulation to the fact that the injuries were caused intentionally doesn't control the state's ability to present proof satisfying the elements of the crime at trial. The evidence was admissible under 404B, and the state was entitled to present that evidence in proving its case. The evidence that defendant abused his son, AH, prior to the abuse of GS was not just general propensity evidence. Rule 404B does exclude evidence of a character trait in an attempt to prove that a defendant acted in conformity with a character trait. So evidence generally that defendant was a violent person or even just an abuser would be the sort of propensity character evidence that 404B excludes. But the state put on much more specific evidence than that at trial and at the 404B hearing. The state put on evidence that defendant had committed the exact same abuse and used the exact same cover-up story previously when he harmed AH. The AH, his son in the prior case, had projectile vomiting. He wasn't eating and had severe nausea. And there were injuries to the occipital bone and contusions on the head that were very similar to GS's injuries. Defendant claimed in both cases that he fed his child 4 ounces before seeking medical attention. He claimed that he used a swing and a crib to calm his child before seeking medical attention in both cases. And the cover stories were almost identical according to the investigating officer of both cases. What that showed was not general propensity evidence of defendant's character. It showed that defendant in this case had an intent to harm his child, didn't do so accidentally, and then covered up that abuse with a story that had worked for him before, a story that was contradicted by pharmacy records in this case, which was part of the overwhelming proof in this case. The trial court had wide discretion after conducting a proper 404B hearing, hearing the evidence with the jury out, and making extensive findings to admit that evidence against defendant. But even if that decision was erroneous, the evidence was overwhelming of defendant's guilt.
Well, as I listen to the state's argument, it seems to me that you are suggesting the state had enough proof to prove beyond a reasonable doubt the injuries that occurred to the first child. And the defendant seems to suggest that there wasn't enough proof to even have a probable cause determination that the defendant was more likely than not to have done this. So how do you get around that? Are we just looking at it two different ways?
Well, Your Honor, I think the evidence of the 404B hearing was at least enough to clear the clear and convincing hurdle. That's the standard for 404B.
Okay.
The state thinks that we've gone beyond that hurdle, that the prosecutor went beyond that hurdle. But the evidence there was similar to this case and similar to a lot of child abuse cases, was that defendant was the only person with control over his child at the time that those injuries occurred.
Well, no, wait just a minute. Is that not disputed?
In this case, Your Honor?
Yes, sir.
Defendant did dispute that, but
did the state produce witnesses that they called that into question, whether he was in their control over the entire time?
Yes, Your Honor. So the evidence at trial here showed that the injuries did occur while defendant had control over the child. So
the state introduced testimony, that expert testimony, that the injuries did occur and that the injuries did not occur during the time, correct?
That's correct, Your Honor. There were
okay.
two.
All right, well, let me ask you this. Are you aware of the rule of threes?
I'm not sure, Your Honor. You may have to.
All right, the rule of threes in a Carol Blackburn case of death, doctors have determined that under certain circumstances, if a person has lost 3 children and the children had been taken to the doctor within 2 or 3 days prior to the death, that they had the caretaker had complained that they were having distress, they were having lung problems. There was no medical diagnosis that there was lung problems after looking at it. The 3rd child that died was murdered. It's propensity evidence, but it has a whole lot of scientific evidence behind it. It is almost impossible that this could occur 3 times, according to the medical experts. But guess what? We've never allowed it in. How do we allow this in? It just sounds like to me you're telling me that if he did it before, he'll do it again.
I understand, Your Honor, and 404B is an exacting standard, and it's a tight line for the state to walk, and it's hard to distinguish sometimes between general propensity evidence, such as a defendant losing a child 3 times and under mysterious circumstances. And I think specifically here, not only the similarity between the injuries, but the similarity between the cover-up stories makes this evidence that was admitted go towards intent and absence of mistake.
Well, what was the cover-up? It wasn't me.
Well, Your Honor, in both cases, defendant not only said it wasn't me, but he explained to the investigating officers that he used a swing in a crib to calm his child, that there was excessive vomiting, projectile vomiting, that he fed his child 4 ounces before seeking medical attention, and then called for medical attention. The problem in this case was that that story was contradicted by pharmacy records, and that was part of the evidence that the jury heard that was overwhelming of defendant's guilt. So defendant's use of this cover-up story that had worked in the past, but was contradicted by the records this time, was evidence of his intent, his intentional abuse of his son, an absence of mistake there.
I failed to grasp it. Maybe I didn't read enough of I've read all the briefs, but what was the overwhelming evidence that contradicted what he said?
Your Honor, there was pharmacy records that showed that about 6:52 p.m., I think, that defendant was at a pharmacy picking up prescriptions when he claimed that he was home taking care of his child, feeding him or swinging him at that time. So in this case, there was physical evidence that contradicted his cover-up story, which had worked for him in the past, but in this case, the pharmacy records showed that the defendant was lying about how he took care of his son during this time that the mother was absent and that these injuries occurred. And beyond beyond even that contradictory evidence that showed that the defendant was lying about how he took care of his son, the jury did hear testimony from two different experts, a medical examiner and a pediatrician. And they both were trying to explain a very confusing area about how to date, how to calculate the time backwards of when these injuries occurred from when the child came to the hospital was declared dead. Both experts testified that within a few minutes of receiving these type of severe injuries to the head, the victim would have started exhibiting very drastic symptoms and gone downhill very quickly. The medical examiner testified that he spotted some amount of coagulation in injuries, which to him indicated that the injuries occurred several hours before the child was brought to the hospital and pronounced dead at that scene there. The pediatrician explained that timing wasn't necessarily exact because there's a lot of factors that can affect coagulation, and emphasized again that these sorts of injuries would cause drastic symptoms and would go downhill very quickly after they occurred. And so both of the state's experts agreed on that these sorts of injuries are not something that could have occurred while the child was at the hospital. Doctors would have noticed, it would have picked up on ultrasound.
Was there ever any evidence about a subdural hematoma?
I think so, Your Honor.
Was there ever any evidence about blood in the retina of the eyes?
I don't believe there was any evidence about blood in that retina of the eyes. I know there was evidence of injuries to the occipital bone, bleeding inside the skull, which would be, I think, the subdural hematoma, and contusions to the head there. That was very extensive.
So there were outside corresponding injuries. Some subdural hematomas do not have outside bruising. They occasion because they're hit with something very, very soft or very padded, like the arm of a chair. A baby's head could be slammed against a padded arm of a chair and tear the vessels inside and cause bleeding, subdural hematomas, which could, of course, result in ultimate death. But there would never be a corresponding bruise outside the head because the outside of the head, those vessels were okay. But if you were hit with a baseball bat, you would expect to have an outside bruise as well as an inside bruise, perhaps. Was there any evidence of outside bruising, you think?
There was, Your Honor. There was testimony about contusions to the head, and that these injuries were caused by blunt force trauma and a shearing force, and not the sort of soft force injuries that might cause internal. And again, the testimony was that the rapid deceleration of the child would have been noticeable to anybody, not just a medical expert. Certainly that the physicians and nurses in the hospital would have noticed if this injury occurred while GS was in the hospital, but that any parent would notice the symptoms beyond the contusions to the head that GS would have experienced after this sort of severe trauma within a few minutes. So, Your Honor, the evidence is overwhelming that defendant was responsible for an intentional injury of GS. The trial court properly admitted evidence that injury was intentional, was not a product of an accident as required by the child abuse statute. But even if the trial court erred in that decision and abused its great discretion in that area, the other evidence was overwhelming and that decision didn't prejudice defendant. For those reasons, we'd ask that this court affirm the judgment.
Let me ask you one other thing about the intent. The fact that there are blunt force trauma that they say caused this. This is experts, both of them said that. And you had expert testimony concerning the contusions that were outside. Are jurors not, I'm sure they're capable of understanding that those are not accidental injuries. So why did you need that other case to even talk about?
Your Honor, two things to that. One is that the state isn't required to just put on the bare minimum of proof in hopes that they just get by the reasonable doubt standard. The state can put on all of the admissible evidence to show that defendant's guilty of the crimes with which he's charged, which is what they did here. And to harken back to Judge Holloway's comment about, they also needed to prove that defendant specifically had that intent, and that not just that these were intentional injuries, but that defendant was responsible for those injuries and then covered them up.
You know, I made that very same argument about 2 hours ago, I think, in a case today that you just made. Boy, this case sure feels different to me. I don't know why, but it does. It's troubling to me.
I think most judges have the experience when it comes to prior bad acts or prior crimes, that the closer those acts or those crimes are to what the defendant is charged with currently, the more difficult it is to conclude that the jury based guilt on the evidence presented about that crime rather than the prior act. And that's what's so concerning about these types of cases to me.
General, would you wager a guess as which was the most qualified expert that testified for the state?
Yeah, I don't know that I could wager a guess on the qualification there. Both experts were qualified in their field, and the jury was entitled to consider all of that evidence. And the pediatrician gave more detailed testimony about exactly how coagulation might be affected by a few factors. But the important thing is that they both agreed that the symptoms of this sort of injury would have been apparent very quickly.
So the one that we generally rely upon on our day-to-day activities in criminal court was rejected, and the pediatrician that, I guess this child's pediatrician, was the one that the jury believed.
You could characterize it that way, Your Honor, though I don't think rejecting one and believing the other was necessarily the choice that we had here. The medical examiner explained the results of his autopsy and his conclusions based on what he saw, and the pediatrician provided more context to what the medical examiner found in that autopsy. And again, they both agreed on substantial portions of their testimony, and it was really finding exactly when this injury could be time-stamped.
Anything further from the members? You wish to conclude, General?
Thank you, Your Honor. It's just asked that you affirm the decision of the trial court.
Thank you. Your 3 minutes, Mr. Ridley.
Okay, I guess I'll start with where we just ended and say that the two experts disagreed on the most fundamental point of this case, which is, when did these injuries occur? And the state's expert, who, as Your Honor suggested, testifies as a forensic pathologist on behalf of the state and paid for by the state on probably a weekly basis, testified that these injuries occurred well before the window in which the state says that the injuries actually happened. So they might have agreed on some things, the pediatrician and the forensic pathologist, but on the most important part, the most important thing, when did these injuries occur? They could not have disagreed more strongly. So
let me ask you, the window that the state presented, was that the window from the time the mother left to go work her shift until around 8 p.m. when the child was taken to the hospital? Is that the window you're talking about?
Right. So I think the state's theory at trial was that at some point after mom went to work, the injuries must have happened. Some point between when mother went to work and when Mr. Huse called the ambulance is the state's theory of when the injuries would have been inflicted. And the forensics pathologist testimony on when the injuries were inflicted simply doesn't match that window at all.
Let me ask one factual question to help me think about this. How long was it after the child was released from 3 days in the hospital with the problems that he had until the child passed away? Was that immediate? Day?
From when he got home from the hospital to when he died?
Right.
Okay, so I think that's probably, so that's early afternoon to that night, so a matter of 6-7 hours, something along those lines.
Yeah, that's what I was wondering.
Okay, so that brings me to my second point. The state, as it did in its brief, keeps coming back to the word overwhelming. Once again, it's not overwhelming when the forensic pathologist cannot testify to the theory that the state wants to rely on. So all that we have left is just speculation. We have some indication that he's alone with the child, or it's undisputed that he was alone with the child at one point. But the only thing that matters is when were these injuries inflicted, and the state's claim of overwhelming evidence is that it had two experts who disagreed with each other.
I'm sorry. There's one thing that really can turn a jury towards a defendant, and that is when they catch him in an out-and-out lie. And if he lied once, he probably lie again. That may be even worse than having a close offense back in your past somewhere that's brought up. But in this case, the state seemed to suggest, as I understand, that he says, I'm rocking my baby, I'm taking care of my baby, and there's absolute proof positive that he was somewhere else getting prescriptions.
Okay, that is the case, that he is the receipt from the pharmacy does indicate that he is picking up prescriptions for the child at the time that he had said he was alone with the child. So that certainly is a contradiction between that pharmacy receipt and what he initially said to the police about the timeline. But what it doesn't do is make the state's case overwhelming. It simply shows that Mr. Huse went to get a prescription per the child's mother's instructions and per the doctor's instructions that were part of his child's discharge orders. As part of the discharge, it was, you need to go get this prescription as part of the child's treatment. Mr. Huse went to do that. Now, obviously, it's not the best thing in the world that his story to the police didn't match those pharmacy records. But does that mean that does not make the state's case overwhelming? It simply shows that his story to the police was inconsistent. It doesn't show that he was hitting this child and causing the child's death. It simply shows that he went to get the child a prescription in accordance with the doctor's instructions. That's all. So that brings us to the second point that Your Honor kind of raised, which is that there was no need, if the state's case was so overwhelming, for the state to spend so much time talking about allegations of abuse from 2008 involving a different child. There was no need to do that. The state now claims, well, you can't control how we present a case. We can put on whatever proof we want to. But that's not what Rule 404B is meant to do. The state mentioned we can't control the state or limit the state's ability, but Rule 404B does that. It says we're only going to do this. We're only going to admit this extremely prejudicial evidence if it goes to a material issue. And there's no material issue here that this would have been relevant towards. And what the state's really doing now, it seems that argument is what it didn't do in its brief, is more or less saying that this is a signature crime. It's saying, look, these cases are so similar. In 2008, this happened, and this happened. Then the same thing happened in 2011. Well, that's not what the state relied on in its brief. It didn't say that this was a signature crime, but that's what it seems to be doing now. But as I think the court is well aware, signature crime requires a lot more than this. It requires a truly unique one-to-one between the prior act and the current act. And we don't have that in this case. And for that reason, yes, Your Honor, I think I need to wrap it up. I'd ask the court to reverse this case and remand it for a new trial.
Thank you very much, gentlemen. It's just, I think I speak for both of the judges with me today. It's just an absolute pleasure to see two lawyers that are prepared and ready to argue. We're having some real good cases today, and y'all have met the bill with the rest of them. This helps us mightily in our chores that we have when we have difficult cases and things are presented to us. But to stand here and to sit here and listen to two good lawyers that know their cases well and present very good arguments. We appreciate them so much. We thank you both for doing that. We'll call Mr. Clerk Hivner back in, and at this particular point in time, we'll let him adjourn court to the call of the next case. Very well done, gentlemen.
This honorable court is now in recess until 2 p.m.